Constitution this week. To review just what we did last week regarding protecting the Provincial Superior Court. There were a couple challenges initially after Confederation challenging some of the constitutionally protected powers of the province to create inferior courts and to appoint judges to them. And then we got into the issue of transferring power to specialized tribunals or transferring unique powers, I suppose, to inferior courts or inferior courts having powers that might be protected under Section 96. And in the reference regarding the adoption in 1938, Justice Duff said that the inferior court powers are now meant to be fixed. We looked at Toronto Corporation versus the Gore Corporation, which was the apex of a strict interpretation of 96, or strict protection of Section 96 powers. And then we moved into John East Iron Works in 1948. And in this case, we had the creation of a test as to whether the Labor Relations Board, whether they were a judicial body, and whether they infringed on Section 96 powers, in the beginning of the RTA test. Then Tomco in 1975, they determined that you need to look at the administrative function of the tribunal or the administrative body, and not just the remedy. Then, in the Residential Tenancies Act, we have the creation of the three-part test. So does the board intrude on Section 96 court powers? Are they operating judicially? And is the core of their operation judicial? And then lastly, generally, the question is the social policy of the board make the transfer of jurisdiction necessarily incidental? And then in Sobeys and Yeomans, they clarify the test and state that the function of the administrative tribunal should be interpreted narrowly and should be characterized by the nature of the dispute. They start talking about whether it's broadly conformable to the powers of Section 96 courts, and start recognizing the overlap of jurisdiction that existed at the time. Then we moved on to the BC Family Relations and Grande. Those cases were cited in Yeomans. With regards to the reference regarding the Young Offenders Act, this was a pretty standard usage of the RTA test, and they found that it was a novel jurisdiction because it dealt with just the crimes of youth and due to the social policy goals of the youth court. So that kind of brings us up to where we are now. Today we're going to be continuing talking about protecting, or finish off talking about protecting provincial superior courts, looking at judicial review, talking about delegation under Section 91 and 92, because the provinces and the federal government often want to cooperate on certain initiatives, and that is, of course, limited under Section 192 due to the exclusivity of those classes of subjects. So then we look at some of the solutions that they came up with, such as conditional grants, administrative interdelegation, incorporation, and conditional legislation. We look at executive federalism as another example of administrative cooperation. And then we turn to threshold issues, and specifically standing. So to continue the protection of Section 96 courts, the McMillan-Bloedel versus Simpson case was a case where a 17-year-old was asked to stop protesting certain, or I guess blocking certain forestry activities in Quiet Sound. So if he did ignore that injunction, then it would be contempt ex facie outside the court, which is exactly what happened. So the conflict here is between the jurisdiction over contempt ex facie of the Superior Court. The Superior Court generally protects the inferior court by punishing contempt ex facie. And the Young Offenders Act says that the Provincial Youth Court has broad and exclusive powers with respect to every contempt of court committed by a young person. So we've got some conflict here with regards to who is going to punish this 17-year-old for ignoring the injunction. Now, the test from the reference regarding the young offenders looks at, I guess the first thing we want to know is, could the youth court have the powers? And the second is, could those powers be excluded from the Superior Court? So, can the youth court have those powers? They do the RTA test. Is the grant of jurisdiction permissible? And then, so this is just what I said. Is it permissible for the Superior Court's jurisdiction to be ousted? So, is it permissible? Lemaire says yes. He whizzes through the RTA test and finds that the power is ancillary to the primary functions of the Superior Court, and the policy reasons of the youth court are laudable, and thus there's no reason why the power can't be shared. And granting the jurisdiction does not infringe on Section 96's jurisdiction. So, can the Provincial Superior Court jurisdiction be ousted? And here he considers what are the core of Section 96 courts, and defines them as powers that are essential to the administration of justice and the maintenance of the rule of law, and determines that punishing contempt is a core, essential part of the Superior Court's powers. He says that removing it or limiting the supervisory function of the court would emasculate it. The McLaughlin dissented in this. She said that the test that Lemaire did was unnecessary, and that the RTA test is a better test than the two questions that Lemaire just asked. With the RTA test, any judicial power can be transferred to an inferior court if the power is ancillary to the tribunal's larger mandate, and the power can be said to lose its judicial character in the administrative context, and of course, because of policy considerations. She also criticized the core test by saying that if accepted, there would be a class of judicial powers which can never be transferred, and that the core in this case should not be described as preservation of orders in proceedings, so that's the supervisory function of the court and the power to punish contempt ex facie, or rather, it should be, the core should be defined as preservation of orders and proceedings and not enforcement of orders. And what she's suggesting here is that they have lots of tools in their arsenal to preserve the order of the proceedings, and they don't necessarily need all of these enforcement of order tools. Courts must conform to the rule of law, and legislation regularly limits the powers of the Superior Court. So it's very possible for the legislature to say that ex facie contempt of court is now only belongs to the youth court. And I think the logic here is that if it's not unconstitutional for the legislature to decide that, which they kind of already did by saying that all matters with regards to youth are to be exercised by the youth court, because of that, it shouldn't be considered a core jurisdiction of Section 96 courts. And with regards to policy, she sort of says it's a mere alteration because it's only ex facia contempt committed by youths that is being removed from the powers of the Superior Court. So she goes on to say that the RTA test is meant to facilitate the transfer of powers to inferior courts, and it strikes a good balance between the provincial legislature's desire to annex effective administration tribunals and the need to maintain the constitutional position of Section 96 courts. But in the end, the result is that they share the jurisdiction. So the youth court can punish contempt ex facia, and the superior courts can punish contempt ex facia. So we move on to reference regarding amendments to the Residential Tendencies Act of Nova Scotia, very similar to the original RTA test, but this turned out a little differently. So the reference was to create a new dispute resolution mechanism. The Director of Residential Tenancies would investigate, mediate, and adjudicate residential tenancy disputes, order the proprietor or tenant to comply with obligations, and the decision could be appealed to the RTA board and then to the Nova Scotia Court of Appeal. So the Court of Appeal, Nova Scotia Court of Appeal, did the RTA test and decided that the ideas were contrary to Section 96. There was a unanimous decision at the Supreme Court level that differed from the appeal court's decision. Lemaire, in a minority here in 1996, decided that, and just remember though that it is a unanimous decision. So the minority decided that the appeal court erred in characterizing the legislation by the remedy, and also the Grandin case back in 1983, that was an error as well, I suppose, by describing the jurisdiction of the new tribunal as lesser leasee relationships. And the way it should be described is by the nature of the dispute, and by characterizing the jurisdiction in this way, or the action of the specialized tribunal in this way, we can then assess whether or not it's novel jurisdiction. Lemaire looks at the reference regarding young offenders and yeomans and sobies, and suggests a new test for determining novel jurisdiction. And again, he's in the minority. Does it respond to a new societal interest? Here he cites urbanization as a new societal, phenomenon that may make this a novel jurisdiction. Is it based on principles of law that make it distinct? And here he says that this is codified versus how how forcing lessors and leasees to comply with orders was dealt with before, which was by enforcing contracts. So here they're codifying the standards of lesser leasee relationships with regards to giving them the power to, or giving the board the power to force them to comply with orders. And thus, and there is a social policy as well, substantive protections to proprietors and tenants. So the majority in this thought that it's not novel, as Lemaire says, that codification and urbanization are not how, are not evidence that it's not, are not evidence that it's novel jurisdiction. The percentage of renters has not changed since 1867, despite urbanization. Codification is not creating novel jurisdiction. And the fact that there's a social policy associated with the legislation is a minor issue in this case, because every statute does that. She also mentions that the reference regarding young offenders and the Sobeys case on which Lemaire bases his test they decide that there's unique jurisdiction in that case because the organizing principles and philosophies in the respective legislation schemes under consideration in those cases were distinctly different from the conceptual basis from the powers exercised by the courts at the time of Confederation. So there was a conceptual distinction I'm going to try and remember here, in reference regarding young offenders, the idea of a youth court and punishment just for, or like a correction system just directed at youth was on a conceptual basis quite different than what was available at the time of Confederation, though that is debatable. And with regards to Sobeys and yeomans, the rules related to unjust dismissal and employer-employee relationships were, I believe, as per lessor-lessee relationships, just organized around contracts. Whereas with regards to Sobeys, there was the protection for non-unionized workers on a kind of collective societal scheme. And I suppose it was the protection of the non-unionized workers that, on a conceptual basis, was quite different than how unjust dismissal was handled in 1867. So simply reorganizing the administrative purposes is not enough. Respectfully, this is not jurisdiction, is what the majority is saying. What they do is simply the RTA test, and they decide that the powers with regards to forcing lessors and lessees to comply with orders was concurrent between the inferior and superior courts at the time of Confederation, and thus it does not violate Section 96. Done. Moving on to judicial review.